Assalamualaikum warahmatullahi wabarakatuh and good day everyone. My name is Muhammad Amirul Izzat bin Lokman Noor and my matrix number 1232274. Today I will be presenting on the topic sources of international law under Article 38 Clause 1 of the ICJ Statute. This presentation focuses on how international law maintains justice and order in society. Let's begin by looking at the definition and the main sources that form the foundation of international law. According to the Article 38, Clause 1 of the ICJ Statute, international law is the body of rules that governs the relations between states. In other words, it defines how countries should behave towards one another, whether in peace, war, or cooperation. The article identifies 5 main sources: treaties, customary international law, general principles of law, judicial decision, and writing of juries. These sources collectively ensure that international law remains consistent, fair, and enforceable across nations. The first and most important source is treaties, also known as conventions. A treaty is a written agreement between states governed by international law. Under Article 38, Clause 1, Paragraph A, treaties become binding once states show consent, either by signing, ratifying, or acceding to them. The principle of pacta sunt servanda, stated in Article 26 of the Vienna Convention 1969, means that agreements must be kept in a good faith. Examples include the UN Charter 1945, which promotes peace and cooperation, and also the Vienna Convention 1969, which regulates how treaties should operate. The second source is customary international law, which is formed by the consistent practice of states follow-out of a sense of legal obligations or obligations. This means that when states act in a certain way repeatedly and believe it is legally required, that practice becomes binding. In the North Sea Continental Shelf Case 1969, the ICJ emphasized that both consistent practice and obligations are needed for a custom to exist. Similarly, in case Nicaragua and United States 1986, the court ruled that the prohibition on the use of force was customary law, even though the U.S. was not bound by a treaty. So, customary law binds all states, not only treaty members. The third source is general principles of law. These are common legal principles recognized by civilized nations, used when there is no treaty or custom to refer to. Examples include good faith, equity, estoppel, and reparation for wrongful acts. In the case Corzo Factory 1928 established that every wrongful act requires reparation. In short, this principle fills the gap in international law to ensure justice and fairness in legal judgment. Next, we have judicial decision and juristic writings, which are subsidiary sources under Article 38, Clause 1, Paragraph D. Although ICJ decisions are binding only on the parties involved, they are highly persuasive for future cases. For example, past ICJ judgments often influence how new disputes are resolved. Meanwhile, writing from scholars like Oppenheim, Brownlee, and Shah help explain, interpret, and clarify international legal principles. These sources don't create new law, but they help strengthen and guide the existing system. In terms of hierarchy, treaties and customary international law are recognized as the primary sources because they are binding and enforceable. General principles, judicial decision, and juristic writings are considered subsidiary sources used when there is no direct rule. At the highest level lies jus cogens, or peremptory norms, which are absolute principles that cannot be violated. For example, the prohibition against genocide and slavery, and also torture. Any treaty or law that goes against jus cogens is automatically invalid. To illustrate, let's revisit 2 landmark cases. In the North Sea Continental Shelf Case 1969, the ICJ clarified that treaty rules only become customary law if there is consistent practice among states. Then, in the case Nicaragua and USA, the court held that customary international law prohibiting the use of force remained valid even when treaty obligations were withdrawn. These cases demonstrate how treaties and customs can operate side by side, ensuring that international law applies fairly to all nations. To conclude, the sources of international law form the foundation of peace, justice, and cooperation in the world. Treaties and customs serve as the main pillars, while general principles and judicial writings ensure that the system remains fair and adaptable. And just conscience remind us that certain moral values like human dignity and freedom are above all agreements. Understanding these sources help us apply international law fairly and uphold justice among nations. That's all from me. Thank you for listening.